Hello and welcome to BYJU'S IAS. Let's get started with the analysis of today's The Hindu newspaper, beginning with a news item on page number 3 of the Delhi edition of The Hindu. Election fever is at its peak. All political parties are trying their best to convince the voters, but child rights organizations, they fear that particularly in rural areas, for the upcoming elections, children may be used during the campaign process. These children are paid in the range of 50 to 100 rupees per day, but despite the fact that they are paid lesser than the adults, they are more energetic, they are more enthusiastic in these campaigns. But in this process, they are exposed to hooliganism, they are exposed to liquor consumption. And that is why this newspaper article is relevant for your GS paper 1, which deals with social issues. But this item is also relevant for your GS paper 2 because according to Juvenile Justice Act of 2015, children under the age of 14 years, they cannot be used in election campaign. It is a crime to use children below the age of 14 in election campaign. But now let's look at this newspaper article in great detail. And we will have to talk about Article 24 of Indian Constitution. Article 24 is a fundamental right. This fundamental right is applicable to children, and this fundamental right talks about prohibition of child labor. To implement this fundamental right, the year was 1986. The Indian Parliament passed a law called Child Labor Prohibition and Regulation Act of 1986. According to this law, children below the age of 14, they are prohibited from working, but where? Only in hazardous industries. That means children below the age of 14, they cannot work, they are prohibited from working in hazardous industries. What are these hazardous industries? Those which are detrimental to the life of a child. For example, deep sea diving. For example, chemicals industry, for example, fertilizers. Similarly, in construction industry, mining, for example. Since these are hazardous industries, children below the age of 14, they are prohibited from working in these hazardous industries. But what about children who are below the age of 14? Can they work in non-hazardous industries? Yes. But even if these children work in non-hazardous industries, their conditions of work will be regulated by the state. That means the state has to ensure that these children work in non-hazardous industries but after their school hours, so that these children, they are not exposed to long hours of working. That means this law allowed child labor. That means a child below the age of 14 can work at a roadside dhaba, can work as domestic maid in the households. That means this law of 1986, it prohibited child labor but only in hazardous industries. But it regulated child labor in non-hazardous industries. That means children can still work in non-hazardous industries, for example at roadside dhabas, as domestic servants in households. Then came the year 2009 when RTE Act, Right to Education Act, was passed by the Parliament. This act got applicable from 1st April 2010, and according to this act, right to education is a fundamental right. That means this law was enacted by the Parliament to give effect to Article 21 capital A of the Indian Constitution, which talks about that every child in the age group of 6 to 14 has a fundamental right to free and compulsory primary education. Then there was a conflict between 1986 law and the right to education law. That means if children in the age group of 6 to 14, they have a fundamental right to education, how can these children work in non-hazardous industries? Now, to resolve this conflict, the Indian Parliament amended this law in the year 2016. Now, this 2016 law makes it absolutely clear that children who are below the age of 14, they cannot work. Whether in non-hazardous industries or in hazardous industries, these children cannot work except in family business and except in entertainment industry. And for the first time, the Indian Parliament talked about children in the age group of 14 to 18. and they are referred to as, in the law, adolescents. The law of 2016 states that adolescents in the age group of 14 to 18, they cannot work in hazardous industries, but they can work in non-hazardous industries. What is the context? We are talking about that children might be used in election campaigns. So activists say that this amounts to child labor. We have a law passed by the Parliament in the year 2016, which primarily was an amendment to the 1986 law. This law makes it abundantly clear that children below the age of 14, they cannot work anywhere. Whether hazardous industry or non-hazardous industry, they cannot work anywhere except in family business and in entertainment industry. Although elections give us entertainment, but it is not an entertainment industry. But at the same time, this law talked about for the first time children in the age group of 14 to 18, and they are referred to as adolescents. And these adolescents can work in non-hazardous industries, but they cannot work in hazardous industries. Many people praise this law, that this 2016 law is in agreement with the Right to Education Act. This is a significant improvement of the 1986 law. But if we dig deeper, this 2016 amendment is not a law which disallows child labor, but in effect it is a law which allows child labor. How? Now see, what is the problem? For example, my family business is, I have a contract with a contractor and I have to manufacture shirts for this contractor. I have a girl child. She goes to school from morning till evening, and then when she is back from the school, I'm forcing this girl child to work in my family business and help me stitch these shirts so that I can abide by the contract of this contractor. But when the girl is in the school, once she is back from the school, she has to do her homework as well, but she does not have the time for the homework because I'm forcing her for my family business. And I'm snatching her innocence. I'm snatching her childhood because I am under the contract of a contractor. Now there is another problem. In our families, the girl child is discriminated against. There is a boy child who is given good education, good clothes, good nutrition as well. And girl children normally are discriminated against. They are not even provided this nutritious food. That means I'm depriving her of nutritious food. I am depriving her of her homework as well, and I'm forcing her to work in my family business because I have to abide by the contract. That means I'm snatching her innocence. And once she is working in my family business, she is exhausted by the end of the day, and she is not in a position tomorrow to get up early in the morning and go to the school again. And ultimately, the school dropout rates increase. That means this is the law which prima facie was passed to disallow child labor, but this law allows child labor because there is no definition of what is this family business. And even if these children are allowed to work after school hours, but these children may not be in a position to work throughout the day, half in school, half in the family business once they are back from the school, and ultimately we are depriving them of their childhood. But there is another problem. Since it is not defined what is this family business, what if my family business is beady rolling? What if my family business is agriculture and I'm forcing my children to spray chemicals and fertilizers in the agricultural field? That means this is the law which does not specifically define what is this family business, and since it is not defined, it is a law which allows child labor. There is another problem. Since this family business is not defined, what is happening in today's India is that there is a big contractor. What he does, he starts a business of beady rolling and starts this business in my name. Why? Because I have 8 children. When I have 8 children, this is a lucrative provision for this contractor. He starts this business in my name so that he can employ 8 of my children in this beady rolling, because these children, after the school hours, they can work in family business. That is one problem with this law. Then these children are allowed to work in entertainment industry as well. For example, as child artists in movies, in television soaps, in reality TV shows. But the reality TV shows are driven by TRP. television rating points. Higher the TRP, higher the revenue for these television companies because of the advertisement revenue. Ultimately, what we are doing, we are forcing these children and exposing these children to naked consumerism. We are snatching them of their innocence when they are forced into unhealthy competition with their competitors in these reality TV shows. So that means this is another way of snatching the children of their innocence. That is what you need to understand from this newspaper article. Now there is another article on page number 5 of the Delhi edition of the Hindu. It talks about West Nile fever. This my colleague has already discussed on 14th of March. Please go through that video lecture to understand everything related to West Nile fever. Now let's look at another issue on page number 7. Life imprisonment is the rule, death penalty is the exception. There is a man in Madhya Pradesh. What this man did, he raped and murdered a 5-year-old girl child. How? First, by gaining the trust of the family of this 5-year-old girl child. He had promised her family that I will drop this 5-year-old girl to the school because my daughter is also studying in the same school. This girl child never returned home and her dead body was found later on. Both the trial court as well as the High Court in Madhya Pradesh concluded that this man should be given death sentence. But the Supreme Court commuted this death sentence and awarded life sentence of 25 years to this man without any remission. That means his sentence cannot be reduced below 25 years. Supreme Court in this landmark judgment said life imprisonment is the rule, but death penalty is the exception to this rule. Every crime should go punished. That means we should punish every criminal. But objectives are two. For every punishment, there are two objectives. Number one, to deter future commission of crimes. That means if I committed a murder, I should be sentenced by the judiciary because it will deter others from committing murder. My life should serve as an example to others that you should also not commit murder because otherwise you will be booked, you will be sentenced by the judiciary. That means punishment should be such that it should deter future commission of the crimes. Second, it should also reform the offender. That means what if I committed this murder in a fit of rage, under the influence of alcohol, so on and so forth. But I have the tendency that I can reform myself and I can be a better asset to the society. That is what Supreme Court highlighted in this judgment. Supreme Court said there is a probability that this man is capable of reform. Why? Because this man did not have a prior criminal record. This is for the first time that this man has committed a crime. And from the time this man was arrested till he was sentenced by the Supreme Court, the conduct of this man has been very good. That means the conduct of this accused has been very good in the jail. Considering the fact that his conduct has been good, considering the fact that he had never a prior criminal record, we can safely assume that there is a provision for reform of this man. And that is why death sentence should not be awarded to this individual, because life imprisonment is the rule. Death penalty is an exception. It is only in exceptional circumstances when the court is sure that we cannot reform an offender. It is in those cases that death sentence should be imposed. That is what you need to understand from this newspaper article. Now let's look at another news on the same page number 7, government's prerogative to frame schemes. Now we have something called separation of powers, legislature, executive, and judiciary. And all these organs have a well-defined role. The role of the legislature is to make laws. The role of the executive is to implement these laws. And the role of the judiciary is to impart justice to the people. But not only do we follow separation of powers, we also follow doctrine of checks and balances. What is this doctrine of checks and balances? That means judiciary will keep a check on executive, judiciary will keep a check on legislature. Legislature and executive will keep a check on judiciary. How? For example, executive is kept under check by the legislature. How? Through confidence motion, no confidence motion, adjournment motion, question hour, 0 hour, motions, resolutions, budget. These are the tools that are available to the legislature, and it is through these tools that legislature keeps executive under check. But legislature in turn is kept under check by the judiciary. That means any law passed by the parliament will be assessed, will be reviewed by the judiciary. And that is the power available with the judiciary, and that is what we call judicial review. That means executive is kept under check by the judiciary as well as legislature. Legislature is kept under check by the judiciary, and judiciary is kept under check by both executive as well as legislature. How? Through appointments and removal. How? The judges are appointed by the executive. The head of the executive is the President of India. The judges are removed by the President, but based on the resolution passed by the legislature. Original Constitution of 1950, when B.R. Ambedkar was debating this constitution in Constituent Assembly, B.R. Ambedkar said that judiciary is one of the most important organs in our constitution. The most important organ is Comptroller and Auditor General. But second most important organ is the judiciary. But since judiciary is important, at the same time independence of judiciary is also very important. But even if independence of judiciary is of paramount significance, but we have to still keep a check on the judiciary. And how? Through appointment and removal of these judges, we can keep a check on the judiciary. But then over a period of time, since the second judge's case of 1992-1993, the appointment of judges is done by the judges themselves. There is a collegium system, Chief Justice of India plus 4 of his senior judges. They recommend names to the President who can be appointed as the judge of a High Court or the Supreme Court. And this name is binding on the President. President may send this name back, but only once. If the same name is recommended by the collegium to the President, again, President has no other option but to appoint this individual. That means because of this second judge's judgment in 1992-1993, India is the only country in the world where judges are appointed by themselves. And removal, such is the complex process of the removal of the judges of the High Court and the Supreme Court that till date, no judge of the High Court or the Supreme Court has ever been removed. That means there is no check and balance on the judiciary as well in practice. In theory, through appointments and removal, there is a check on the judiciary. But in practice, there is no check and balance so far as judiciary is concerned. And it is because of these powers that there is no check and balance on the judiciary and this power of judicial review, that now what judiciary is doing, it is encroaching into the domain of the executive. It is encroaching into the domain of the legislature. That means today judiciary is also making laws. How? Look at the 1997 judgment, Vishaka Guidelines. Supreme Court laid down various rules, and because of these rules, the sexual harassment of women at workplaces can be curtailed. That is what we call Vishaka Guidelines. And this Vishaka guideline is just like the law passed by the Supreme Court. That means any order given by the Supreme Court under Article 141 of the Indian Constitution, it is said that this order is like the law of the land. And since Vishaka guidelines were laid down by the Supreme Court in 1997, it became law of the land. That means judiciary has encroached into the domain of the legislature and it has passed a law. And that is what we call judicial legislation. And judiciary is also encroaching into the domain of the executive. How? In UPA 2 era, 122 2G licenses were cancelled by the Supreme Court. On what grounds? Supreme Court said that the government of the day followed first come, first serve basis policy. Instead, what the government should have done, government should have auctioned this spectrum. Supreme Court said this policy of the government is invalid, is unjust, is unreasonable, and that is why this policy is struck down. This judgment of the Supreme Court was heavily criticized at that point in time because it was argued that even if the policy is flawed, but making policy is the domain of the executive. Executive has the prerogative to frame policies and programs and schemes. Why should Supreme Court interfere whether the government should have followed first come first served basis policy or government should have auctioned the spectrum? Then in various judgments, Supreme Court made it clear that judiciary should not enter into the domain of the executive and should not question the policy making of the executive, because policy making ultimately is the job of the executive under the theory of separation of powers. But now what happened? Uttarakhand High Court, and Uttarakhand High Court is notorious for such judgments. Some time ago, Uttarakhand High Court declared that Ganga and Yamuna, they are living entities. That means since they are living entities, they are jurisdic personalities. As jurisdic personalities, they can also file a petition before the High Court and the Supreme Court of this country, because they are treated as living persons by the Uttarakhand High Court. But then the questions were raised about who can file a case on behalf of Ganga or Yamuna. Ultimately, Supreme Court struck down this verdict. But now Uttarakhand High Court has come out with another scheme. And what is that scheme? Some casual workers who were engaged by Border Roads Organization, they were casual workers, that means they were not regularized, they were not permanent employees. They approached the Uttarakhand High Court that we should be regularized. We should be provided permanent employment. And what Uttarakhand High Court did? Uttarakhand High Court started framing a scheme to regularize these employees. But now Supreme Court has said that courts should stay out of this executive domain. The government's prerogative is to frame policies, programs and schemes. It is not the domain of the judiciary to enter into the area of influence of the executive. But whether even this judgment will be adhered to by the judiciary, we don't know. Because judiciary has the habit of entering into the domain of legislature and executive on the grounds that Constitution allows it under Article 142 of Indian Constitution. And what is Article 142 can be relevant for your prelims 2019. Article 142 declares Supreme Court can issue any order so as to provide complete justice to the petitioner. And it is this phrase of complete justice that is giving a huge area of influence for the judiciary, and it is because of this complete justice doctrine that judiciary is encroaching into the domain of executive and the legislature. That is what you need to understand from this newspaper article. Now there is another important article on page number 18, India on the brink of dry eye disease epidemic. What is this dry eye disease? Primarily the dryness in the eye, and it is caused due to inadequate tear production. Tears are not adequately produced. That is what causes itchiness in the eyes. That is what causes dry eye. Second, it may be because of tear film instability. This is another reason what causes dry eye. An expert says sometimes it can be a mix of both, caused by tear production which is inadequate, as well as tear film instability, and that is what causes dry eye. And this report suggests that age can be a factor for dry eye, urban residence, occupation, socio-economic affluence among the risk factors for the development of this disease, and India is on the brink of an epidemic. But now let's look at a related concept to this. Let's say, for example, you have a dry eye. Now what you do, you start excessively rubbing your eye. If you start excessively rubbing your eye, what happens? There is a cornea which is normally round. If you start excessively rubbing your eye, this cornea, it becomes thin. And over a period of time, this round shaped cornea, it turns into a cone shaped cornea. And this cone-shaped cornea is what we call a disease called keratoconus. So keratoconus can be a potential question for your prelims examination. That means if your eyes are dry, you excessively start rubbing your eye. Because of this, what happens? Your cornea becomes thin, and this thinning of cornea makes this cornea to bulge out like a cone, and this disease is what we call keratoconus. And as of now, there is no cure for keratoconus. Although some doctors do recommend that there is something called C3R, collagen cross-linking using riboflavin, but that becomes too technical. It is not important for your exam. But what is important is this keratoconus, which might be a potential question because dry eye disease epidemic is mentioned in this newspaper article. Let's look at what type of question can be asked on this issue. Consider the following statements regarding keratoconus. It is an eye disease in which normally round cornea thins and begins to bulge into a cone-like shape, correct? It is a non-progressive disease in nature. No, it is a progressive disease. That means it progresses over a period of time. Some doctors say that till you are 30 years of age, this keratoconus will progress. But once you complete 30 years of age, your cornea matures and then it no longer thins, it no longer bulges. And if bulging does not stop, then the only solution is cornea transplant. This disease is hereditary in nature. As of now, what causes keratoconus, nobody knows. Some say it is a mix of hereditary as well as excessive rubbing of the eyes, but there is no conclusive evidence to suggest that this disease is hereditary in nature. So which of the above statements are correct? Only one. Now let's look at some of the editorials from today's The Hindu newspaper, beginning with Lokpal at last. In yesterday's newspaper analysis, I explained you the details about Lokpal, and I told you that Justice P.C. Ghose is all set to be India's first Lokpal. This editorial talks about two things. This editorial says that despite the fact that the law was passed in the year 2013, but it took close to 5 years for the government of the day to finally appoint a Lokpal, nevertheless, it's a welcome decision, and this appointment of Lokpal should be welcomed by all. But this editorial talks about two things: the role of Anna Hazare and the role of Supreme Court. This editorial says that at least some of the credit for the appointment of Lokpal should be given to Anna Hazare, because it was Anna Hazare and his India Against Corruption movement of the year 2011 where activists, writers, actors, they all got together in Delhi at Jantar Mantar, at Ram Leela Maidan, at many places, and forced the then government of the day to enact a strong Lokpal, strong anti-corruption ombudsman. So at least some of the credit should be given to Anna Hazare, and some of the credit should be given to the Supreme Court. Because it was only after the final warning issued by the Supreme Court that government was forced to appoint P.C. Ghose as the Lokpal of this country. Because according to this editorial, the government of the day was reluctant in appointing the Lokpal. But how can we say that the government was reluctant? Government was at every point in time telling the Supreme Court that we are not appointing a Lokpal because we do not have leader of opposition. It is this vacancy in the office of leader of opposition that we are not in a position to appoint a Lokpal. But this editorial points out to inconsistency. The inconsistency is that in the appointment of CBI director, leader of opposition was required, but the parliament amended the law and provided for leader of opposition or leader of the single largest party in Lok Sabha. Similarly, in the appointment of the Chief Information Commissioner, leader of opposition was required, but the government of the day tweaked the rules, modified the rules, and ensured that if leader of opposition is not present, he should be replaced by leader of the single largest party in Lok Sabha. So what stops the government from implementing a similar policy for appointment of Lokpal? They could have cleared a one-line amendment of the act and added leader of opposition or leader of the single largest party in Lok Sabha. And that is why, without the interference from the Supreme Court, this appointment of Lokpal would not have been a reality. But this editorial also says that it may be unrealistic to expect any dramatic impact on the lives of the common people. But nevertheless, the Lokpal has an historic responsibility now to live up to the popular expectations of the people, because people hope that public servants, Prime Minister, ministers, they all will be held accountable by this institution called Lokpal. That is what you need to understand from this newspaper article. Now let's look at a column on page number 7, a fatal margin of error it is related to capital punishment. Supreme Court in Bachchan Singh versus State of Punjab in the year 1980, Supreme Court said capital punishment should not be awarded in all cases, but capital punishment should be awarded only in rarest of rare cases. And what are these rarest of the rare cases? Supreme Court did not elaborate. 2 years later in 1982, in Machi Singh versus State of Punjab, the Supreme Court elaborated what is this rarest of the rare doctrine. Supreme Court said whenever the judiciary is hearing a case, the court should draw a balance sheet of aggravating circumstances and mitigating circumstances. If in a particular case, aggravating circumstances are more than mitigating circumstances, or aggravating circumstances dominate mitigating circumstances, only then capital punishment should be given. Otherwise, life imprisonment should be awarded. But what is the difference between aggravating circumstances or mitigating circumstances? Aggravating circumstances, there is something unique about the crime. For example, the Delhi gang rape. When Nirbhaya was gang raped in a moving bus in December 16, 2012, there was something uncommon, horrific about that crime. Because this lady, she was gang raped in a moving bus, and then these rapists, they took turns in raping her. Then these rapists, they injected an iron rod into her genitals, which also ruptured her intestine. So there was something grotesque, there was something horrific about this crime. These are aggravating circumstances, something unusual about that crime. But what are the mitigating circumstances? Maybe the accused who raped or who committed murder, maybe he is a first-time offender. There is no past criminal record against this individual. Maybe he committed this murder because he belonged to poor section of the society. That doesn't justify his crime, but it is only a mitigating circumstance. For example, my family has not eaten in the last 1 week. I approach a shop, I ask a piece of bread from the shop owner, but the shop owner pushes me to the back, slaps me. In turn, what I do, I take out a knife and I kill the shop owner. This does not justify my crime, but there is a mitigating circumstance in my favor because I committed this crime because my family was starving. That doesn't mean I should be let off, but that only means that I should not be awarded death sentence, but I should be awarded life imprisonment. That means Supreme Court in Machi Singh case said a balance sheet should be drawn which lists aggravating circumstances as well as mitigating circumstances. Mitigating circumstances speak in favor of the accused and aggravating circumstances speak against the accused. And let's check whether aggravating circumstances dominate the mitigating circumstances or vice versa. To understand this in detail, let's take two examples. Khushwinder Singh versus State of Punjab, and in late 2018, M.A. Antony versus State of Kerala. In this case, the accused killed 6 relatives of his wife. In this case also, the accused killed 6 relatives. So the case is identical. In both the cases, the motive was theft. Motive was money. In both the cases, the accused was known to the victims. In both the cases, the accused were middle-aged men. That means there is some similarity between the two cases. Both the cases, there are stark similarities. But in this judgment, Supreme Court said death penalty should be given to the accused. In this case, the Supreme Court said no, commute this death sentence to life imprisonment. Why? Because in this judgment, the Supreme Court took a view of the mitigating circumstances which speak in favor of the accused. Because in this case, the Supreme Court said that there is still an opportunity that this offender can be reformed. But in this judgment, the Supreme Court did not take into account the mitigating circumstances. This speaks volumes about why capital punishment should be abolished in this country. Because it is this inconsistent and arbitrary application of death penalty that remains a matter of great concern according to the writer. Because if there is different treatment in similar circumstances, is it not violative of Article 14 of the Indian Constitution, which talks about equal protection of the laws? Equal protection of the law states explicitly that in similar situations, laws must be equally applied, similarly applied. But it is this dissimilar treatment in similar circumstances that makes this doctrine of rarest and rare as an arbitrary application, and that is why capital punishment should be abolished in this country, according to the writer. But there is a detailed video lecture available on our YouTube channel on capital punishment. Please watch that video. Therein I have presented the arguments in favor of capital punishment as well as arguments against capital punishment. That is what you need to understand from this newspaper article. Now let's look at another column on page number 9, future-proofing cities. There is a rapid urbanization going on. It is both rapid as well as rabid. Urbanization, people from rural areas are migrating to the cities, but in cities the infrastructure is not developed. That means, according to various reports, half of the infrastructure that is needed in Asia by 2050, it is yet to be created. It is yet to be built. But if you think that this is a cause of concern, think twice, because this can also be a silver lining. This can also be a blessing in disguise. Because if half of the infrastructure that is required by 2050 is yet to be built, we can build this infrastructure, but keeping in mind that this infrastructure should be resilient. This infrastructure should be such that earthquakes, volcano eruptions, tsunamis, etc., these infrastructures should withstand these natural disasters. Let's say, for example, these are buildings. Now there is an earthquake or there is a tsunami. Earthquake and tsunami kills lesser number of people, but the crashing of these buildings kill more number of people. World Bank states that annual losses because of disasters or natural disasters is close to 520 billion every single year. And these natural disasters push 24 million people every year into the lap of poverty. It is important to build infrastructure that is resilient to shocks brought about by climate change. That is what you need to understand from this newspaper article. But there is one MCQ that I have provided related to this, and that is Sendai Framework. Consider the following statements with reference to Sendai Framework. It is a binding agreement to reduce disaster risk. It is not binding, so this statement is wrong. It is a successor of Hyogo Framework, correct. The Sendai Framework for Disaster Risk Reduction charts the global course for the next 1 decade. No, it is for the next 15 years. So which of the above statements are correct? 2 only. What is the explanation? Sendai Framework for Disaster Risk Reduction talks about period 2015 to 2030. And it is the first major agreement of the post-2015 development agenda. Sendai Framework is a 15-year voluntary non-binding agreement, and it recognizes that state, which is the government, this state has the primary role to reduce disaster risk. But this is not the only responsibility of the state. This responsibility state should share with private sector as well, because they should also be responsible for reducing the disaster risk. And this disaster framework or Sendai Framework is the successor instrument to Hyogo Framework for Action 2005-2015. Now let's look at some of the prelims based questions, beginning with from today's paper. Which of the following statements are true regarding anti-defection law? An independent legislator joining any political party 6 months after the elections shall be disqualified under the 10th schedule. This statement is wrong, because you don't have to wait for 6 months. An independent legislator, immediately after the election, if he or she joins any political party, this individual will be disqualified under anti-defection law. That's one statement. Anti-defection law does not apply if 2/3 members of a political party defect. This statement is correct. So which of the above statements are correct? Only 2. What is the context? In today's newspaper, the wife of the late actor Ambarish and former union minister, she has decided to contest as an independent candidate from the Mandya constituency in Karnataka. And later on, if she joins Congress party again, or if she joins BJP, provided she wins the election, then she will be disqualified from Lok Sabha. And what is the second statement? We have seen that two members of a political party in Goa, they have defected from their political party and joined the BJP. But since the number of members of that political party were only three and two members defected to BJP, in this case, anti-defection law does not apply. Map-based question. It's a country in Western Asia at the southeast end of the Arabian Peninsula on the Persian Gulf. This country borders Oman to the east and Saudi Arabia to the south, as well as shares maritime borders with Qatar to the west and Iran to the south. Which country is being referred to in the above statements? It is United Arab Emirates. This is UAE, borders Oman in the east as well as Saudi Arabia to the south, shares maritime border with Qatar as well as Iran. What is the context? UAE helped diffuse India-Pakistan tension, says the envoy of UAE to India. Previous year's prelims based question 2018, the staple commodities of export by the English East India Company from Bengal in the middle of the 18th century were cotton, silk, saltpetre and opium. That is it from our newspaper analysis for today. Thank you for being with us. Have a great day.